Welcome, everyone, and thank you for joining us for our webinar, The Corporate Transparency Act, Beneficial Ownership Reporting and What You Need to Know, presented by Quarles. My name is Brian Mall. I'm a partner in the Quarles Phoenix office. My practice focuses on general corporate law, mergers and acquisitions, venture capital, entity formation, corporate governance, and commercial contracts. I advise startups, middle market companies, and private equity-backed portfolio companies. We'll begin the presentation as soon as we cover a few logistic items. First, unfortunately, my colleague Zach could not join us today, so I will be the sole presenter here. All comments in today's webinar are off the record and not for publication. All attendees are in listen-only mode, but we welcome your questions via the Q&A box located below the slides in the webinar dashboard. If we don't have time to answer all questions during the webinar, we'll follow up over email. Quarles is happy to be able to provide CLA credit in most U.S. jurisdictions for Quarles webinars. As of April 2024, the American Bar Association manages the CLA applications, attendance submissions, and certificate of attendance for our external webinars. We have updated procedures for tracking attendance for CLA credit. They include you must be logged in, participating from your own device, and need to actively watch the entire webinar. Please watch for pop-up polls with audio notifications that will appear at several random times during the webinar. You must click on the pop-up polls to verify your attendance. Regulators require attendance to be verified, and this procedure meets that requirement. Please take a moment to review the resources box below the video feed, where you'll find a copy of today's presentation, a survey link to share your feedback, and CLE application information. You can access closed captioning during the live webinar by clicking on the CC icon in the lower right-hand corner of the video player. Today's webinar is being recorded. All registrants will receive the on-demand link within a few days. With that, we'll get started. All right, so here's what we're going to cover today: how the Corporate Transparency Act works, what is a reporting company, exemptions to the CTA, determination of beneficial owners, timing for filing beneficial reporting reports, enforcement and penalties, and then we'll have some Q&A at the end. Okay, so the CTA, this was an act passed in 2021. The intent was to go after bad actors who hide ill-gotten gains through shell companies and other opaque ownership structures. And how this works. So the CTA requires all reporting companies to file a beneficial ownership report with FinCEN. Reporting companies created or registered on or after January 1st, 2024, and before January 1st, 2025, have 90 calendar days after receiving actual or public notice that their company's creation or registration is effective to file their initial BOI reports. Reporting companies created or registered business before January 1st, 2024, will have until January 1st, 2025 to file their initial BOI reports. Reporting companies created or registered on or after January 1st, 2025 will have 30 calendar days from the actual or public notice that the company's creation or registration is effective to file their initial BOI reports. Beneficial ownership reports identify each beneficial owner, and for companies created after January 1st, 2024, each company applicant of the reporting company. And we'll cover those in some more detail later on in the presentation. One thing to point out is if a company is exempt, meets one of the 23 exemptions we'll talk about, nothing needs to be filed with FinCEN. Here's kind of the basic CTA compliance process. So if your entity is a reporting company, no, nothing needs to be done. Yes, then you need to look to see if an exemption applies. If one does, nothing needs to be done. If not, you're not exempt. You need to identify all beneficial owners and collect the required information and file it with FinCEN. What is a reporting company? So a reporting company requires all reporting companies to file BOI reports with FinCEN. A reporting company is any U.S. domestic entity created by a filing with a Secretary of State or similar office under the laws of a state or Indian tribe, or any foreign entity registered to do business in the U.S. Now, these will by typically you form LLCs, corporations, limited liability partnerships, Delaware statutory trusts. We have the two asterisks there for limited partnerships and general partnerships. If in a state you do not need to file anything with a Secretary of State or similar office, those entities would be exempt and there would be no BOI filing requirements. Also, sole proprietorships are exempt as well, because typically you don't file anything with the Secretary of State to be a sole proprietor. Okay, exemptions to the CTA. There are 23 specific exemptions for reporting companies whereby no report is required to be filed. I've got highlighted on the left, which probably is the most common ones that we'll see: a large operating company, subsidiaries of certain exempt entities, securities reporting issuer, tax exempt entity. And there's some others there you see, like an accounting firm, public utility, inactive entity, which we'll talk about later, credit unions, banks, insurance companies, financial market utility, venture capital fund advisor, those things. So if you qualify for any of these exemptions, no filing is required. So I think most folks on the phone or on the webinar today probably work for, or the most likely exemption would be a large operating company. Now, these are the requirements. The entity employs more than 20 full-time employees when applying the meaning of full-time employee as provided in the CFR. In general, full-time employee means, with respect to a calendar month, an employee who is employed an average of at least 30 hours of service per week with an employer. You have to have more than 20 full-time employees employed in the United States. The entity has to have an operating presence at a physical office within the United States. The entity filed a federal income tax or information return in the U.S. for the previous year demonstrating more than $5 million in gross receipts or sales. If the entity is part of an affiliated group of corporations, you could look at the consolidated return. The entity reported this greater than $5 million amount as gross receipts or sales net of returns or allowances on the entity's IRS Forms 1120, Consolidated Form 1120, Form 1120S, Form 65, or other applicable IRS form. When gross receipts or sales from sources outside the United States as determined in the federal income tax principle are excluded from the entity's amount of gross receipts or sales, but it still has to remain above $5 million to qualify. One thing to note here is you cannot consolidate employees across companies to meet the more than 20 employee requirement. So for each entity, they have to have more than 20 employees. Subsidiaries of certain exempt entities also do not have to comply with the BOI information requirements. So I've listed some of the main ones here. So if you're a securities reporting issuer, public company, insurance company, tax exempt entity, large operating company. Now the key here is the subsidiary has to be wholly owned or wholly controlled to qualify. Meaning the parent company can't own 60%, 80%, or have control through voting or other requirements less than 100%. Securities reporting issuer, obviously these are public companies. In order to qualify, either of the two following criteria has to come into play. So the entity is an issuer of a class of securities registered under Section 12 of the Securities Exchange Act of 1934, or the entity is required to file supplementary and periodic information under Section 15D of the Securities Exchange Act. One thing to note is that I had a client question on this is, if you're a public company, say in Canada or the UK, that does not exempt you and your subsidiaries operating in the US from the BOI information filing requirements. Tax exempt entities. So an entity qualifies for this exemption if any of the following four criteria apply. The entity is an organization described in Section 501C of the Internal Revenue Code of 1996 as exempt from tax under Section 501A of the Code. The entity is an organization described in Section 501C of the Code that was exempt from tax under 501A but lost its tax exempt status less than 180 days ago. The entity is a political organization as defined in Section 527E1 of the Code that is exempt from tax. And the entity is a trust described in paragraph 1 or 2 of Section 47A of the Code, which is typically a charitable trust. Inactive entity exception. So many of you probably have some entities in your organization that have been dormant, but it's important to note that all 6 of the following have to apply if the entity is to be deemed an inactive entity and exempt from the filing requirements. So the entity was in existence on or before January 1st, 2020. The entity is not engaged in active business. The entity is not owned by a foreign person, whether directly or indirectly, wholly or partially. The entity has not experienced any change in ownership in the preceding 12-month period. The entity has not sent or received any funds in an amount greater than $1,000, either directly or through any financial account in which the entity or an affiliate of the entity had an interest in the preceding 12-month period, and the entity does not otherwise hold any kind or type of assets in the U.S. or abroad, including any ownership interest in any corporation, LLC, or other similar entity. Dissolved entities. So I'm thinking many of you would think you can dissolve the entity this year and not be subject to the BOI filing requirements, and that actually is not correct. So the CTA reporting requirement applies to companies active on or before January 1st, 2024. There is no exception for companies to dissolve after January 1st, 2024 date and before January 1st, 2025. For example, company dissolves June 1st, 2024, company was still active on the key date of January 1st, 2024. Therefore, it would still need to file a report at FinCEN by the deadline of January 1st, 2025. The dissolution on January 1st, 2020 does not relieve it of the reporting obligation. Now, that's not to say if you dissolve the end of this year, you have to file, but then after the filing is made and you dissolve the entity, you could file an update with FinCEN to say that the entity is dissolved and is now exempt. Also, something to think about if you try to restructure your entities. If you have a bunch of subsidiaries to a holding company structure and you try to replace those subsidiaries under an exempt large operating company this year, you still would need to file. Now, once you restructure your operations to have these subsidiaries as exempt under a large operating company, you could file an amendment with FinCEN to say that that entity is now exempt. Next is determination of beneficial owners. Each reporting company needs to identify which owners will need to report to FinCEN. Beneficial owners are individuals who directly or indirectly fulfill one or both of the following. So ownership. Individuals own at least 25% of the ownership interest of a reporting company. Definition of ownership interest is wide-ranging and generally includes all categories of security. Fact-specific inquiry based on entity and types of securities involved. Substantial control is another factor. Individuals who have substantial control over their reporting company if they serve as a senior officer, have authority over the appointment or removal of senior officers, majority of the board, direct, determine, have substantial influence over important decisions of the reporting company, or have any other form of substantial control. So here's a good chart that kind of shows. So we have the senior officers. They're listed there. And any other officer, regardless of the official title, performs similar function as these officers would be required to report information. Appointment or removal authority, any individual with the ability to appoint or remove any senior officer or a majority of the board of directors or similar body. Important decision makers. You see the list over here. So any individual who can have an influence over the business, such as nature, scope, and attributes of the business, the selection or termination of business lines or ventures or geographic focus, the entry into or termination of fulfillment or non-fulfillment or significant contracts, finances, such as sale, lease, mortgage, other transfer of any physical assets, save a debt, or approval of the operating budget, compensation schemes, incentive programs, senior officers, structure. Can this person influence a reorganization, dissolution, or merger? Amend any substantial governance documents, including articles, bylaws, operating agreements, etc. And then there's this catch-all category. So it's any other form of substantial control of the reporting company. Control exercised in new and unique ways can still be substantial. For example, flexible corporate structures may have different indicators of control than the indicators included here. So on the safe side, any of these folks who trigger these things you should collect the information and report them to FinCEN, their beneficial information. Determination of beneficial owners, a 25% test. Who owns the 25%? So you calculate this on a fully diluted basis. You look at the individual who have any options or convertible securities being treated as exercised. Tax partnerships measure percentage of outstanding capital and profits for reporting companies that issue capital or profits interest, including existing entities treated as partnerships for federal income tax purposes. The individual's ownership interest are the individual's capital and profits interest in the entity, calculated as a percentage of the total outstanding capital and profits interest of the entity. Corporate ownership rule. For corporations, entities treated as corporations for federal income tax purposes, and other reporting companies that issue shares of stock, the applicable percentage should be the greater of the total combined voting power of all classes of ownership interest of the individual as a percentage of total outstanding voting power of all classes of ownership interest entitled to vote, or the total combined vote value of the ownership interest of the individual as a percentage of the total outstanding value of all classes of ownership interest. And finally, the fail-safe rule. If the facts and circumstances do not permit the calculation described either above to be performed with reasonable certainty, any individual who owns or controls 25% or more of any class or type of ownership interest of a reporting company shall be deemed to own or control 25% or more of the ownership interest of the reporting company. Now, there are certain exceptions from the beneficial ownership definition. This would exempt them. If they would otherwise be a beneficial owner, these are folks that are exempt from the BOI reporting requirements. Minor child. So the individual as a minor child is defined in the laws of a state, Indian tribe, in which the domestic reporting company is created or the foreign reporting company is first registered. The reporting company may instead report information about the parents or legal guardian of the minor child. This exception only applies if the parent or legal guardian information is reported in lieu of the minor child's information. Also, when the minor child reaches the age of majority, as defined by the law of the state, Indian tribe in which reporting company is created or first registered, the exception no longer applies. At that time, the individual is a beneficial owner. The reporting company must file an updated BOI report providing the individual's own information. Next, we have a nominee, intermediary, custodian, or agent. This is where the individual merely acts on behalf of the actual beneficial owner as the beneficial owner's nominee, intermediary, custodian, or agent. Individuals who perform ordinary advisory or other contractual services, such as tax professionals, likely would qualify for this exception. In this scenario where the exception applies, the actual beneficial owner must still be reported. Employees. So generally, employees who meet these three criteria are exempt as well. So the individual employee of the reporting company, generally the term employee means that the individual is subject to the will and control of the employer and what and how to do work, and that the employer may discharge the individual from work. The individual's substantial control or economic benefit from the reporting company derives solely from the employment status of the individual employee. The individual is not a senior officer of the reporting company. An inheritor is the next exemption. So this is the individual interest in the reporting company as a future interest through a right of inheritance, such as through a will providing a future interest in the company. Once the individual inherits the interest, this exception would no longer apply, and the individual may be creditor. So the individual is a creditor of the reporting company. The term creditor means an individual who would meet the definition of beneficial owner of the reporting company solely through rights or interest for the payment of a predetermined sum of money, such as a debt incurred by the reporting company, or a loan covenant or other similar right associated with such right to receive payment that is intended to secure the right to receive payment or enhance the likelihood of repayment. For example, an individual qualifies for the creditor exemption if the individual is entitled to payment from the reporting company to satisfy a loan or debt, so long as this entitlement is only ownership interest the individual has to the reporting company. So company applicants. This information applies when entities are formed after January 1st, 2024, and each of up to 2 company applicants must also be identified and provide their unique data to FinCEN. A company applicant is any person who files a document to form the reporting company. In the case of a foreign entity, files a document to register to business in the U.S. and or includes any person who directs or controls the filing, such as an attorney, supervising work, a paralegal, or using a corporate service provider. So here's a chart showing company applicants. You can see, was the reporting company created after January 1st? If yes, report the company applicant 1. If more than one person is involved, you have to report company applicant number 2 information. So here's a couple of examples. And I think these will be helpful to determine company applicants. So example 1, individual A is creating a new company. Individual A prepares the necessary documents to create the company and files them with the relevant state office, either in person or using a self-service online portal. No one else is involved in preparing, the directing, or making the filing. Individual A is the company applicant because they filed it. Because it's only individual A, that's the only person that needs to file the information, the BOI information. Example number 2, individual A is creating a company. Individual A prepares the necessary documents to create the company and directs individual B to file the documents with the relevant state or travel office. Individual B then directly files documents that creates the company. In this case, individuals A and B are both company applicants. Individual B directly filed the documents. Individual A was primarily responsible for directing or controlling the filing. Individual B, for example, could be an individual spouse, business partner, attorney, or accountant. In all cases, individual A and B are both company applicants in this scenario. Another common example would be for me. Okay, I have a client. I oversee the preparation of their articles of incorporation. I ask my paralegal to prepare it. We send it to CT Corp for filing. I would be one of the applicants, the company applicants, and the individual at CT Corp would be the second company applicant, and that information would need to be provided. Timing for beneficial ownership information. So as we kind of talked about, within 90 days, that's for new entities formed in 2024. Within 1 year, this would apply to initial reports for entities formed before January 1st, 2024. Effectively existing companies prior to the act of the CTA must file by January 1st, 2025. And then you have this requirement within 30 days. So any entity formed after January 1st, 2025, you have 30 days to report the BOI information. Updated reports for any changed information, e.g. company adds a senior officer, ownership changes, etc. Corrections to reports, if you find the information was inaccurate, you need to file that within 30 days. And one thing I think for companies out there, you probably need to put a process in place to track this. Request information from those people who are required to provide BOI information, set a process in place, collect information within 30 days. I know it's going to be somewhat of a burden, but it's probably good to start these processes after you file your initial filing report. Here's information to collect on reporting companies. So reporting company, you want the full legal name of the entity, any trade names or DBAs, complete current U.S. address. It has to be a principal place of business in the United States, not a PO box. State, tribal, or foreign jurisdiction of formation. For a foreign reporting company only, use the state, the jurisdiction of first registration. Internal Revenue Service, you need the tax identification number. If a foreign reporting company does not have a TIN, you can report the tax identification number issued in a foreign jurisdiction and the name of such jurisdiction. So for each beneficial owner and company applicant, you need to report the full legal name of the individual, date of birth, complete current address, report the individual's residential street address, except for company applicants who form or register a company in the course of their business, such as paralegals. You'd obviously use the law firm address. Unique identifying number and issuing jurisdiction, such as U.S. passport, state driver's license, identification documents by state local government. If the individual does not have the previous documents, use their foreign passport. Enforcement and penalties. So you want to make sure to avoid any penalties for failure to file late filing. So when any individual reporting company willfully fails to report or causes a reporting company to fail to report complete or updated information, or willfully provides or attempts to provide false or fraudulent information, you're subject to fines and penalties. The CTA provides for both civil and criminal penalties for violations. Civil penalty, $500 per day if the violation continues or has not been remedied. Criminal fines up to $10,000 and imprisonment for up to 2 years. Now, we don't know what the enforcement action is going to be by FinCEN. We haven't seen any guidance on that yet. So we don't know how vigorously they're going to enforce this, what type of penalties they're going to do. But in the interim, I mean, I think everybody should comply with the filing requirements. Resources. If you go to the FinCEN website, there are good resources there. There's a small business compliance guide with really good checklist and other information regarding compliance, exemptions, filing requirements. And there's also a frequently asked questions guide as well. Now, the one thing probably some of you may be aware of, there have been legal actions that challenge the CTA Act. There was a court case filed in Alabama. There was a decision on March 1st. That court found the CTA unconstitutional for exceeding certain limits on congressional power. That action, though, only applied to the plaintiffs, and the FinCEN said it applied to the national SBA members. It was brought by the SBA and some other plaintiffs in a court in Alabama. It's been appealed to the 11th Circuit. There's also a case that was recently filed in Michigan. It was filed by the SBA of Michigan and other plaintiffs. They're focusing on some additional legal arguments such as Fourth and Fifth Amendment violations. And I think these courts, I mean, we'll have to see what the 11th Circuit does, but I think the recommendation, if you form a new entity, you should file and complete the requirements within the 90-day period. For other entities that were formed prior to January 1st, 2024, I think you can take a wait and see approach. You should actively collect the information, but kind of wait to see how these court cases come out. We're not sure, some of the commentators out there, I mean, if this gets to the Supreme Court, most commentators think that the CTA Act will be found constitutional, but we could have split decisions. It could go to the Supreme Court. We'll have to see what the 11th Circuit does on overruling or confirming the decision of the Alabama lower court. Now, I think what may be helpful here, and I put this in here as some examples, as we can see, which may be helpful in determining whether or not you're subject to compliance. So example number one, we have a reporting company, type of entity, LLC, ownership interest, capital, profits interest only. We have individual A owns 100% of the entity, and he's the president and makes the important decisions. So here we go. Individual A is a beneficial owner of a reporting company in two different ways. Assuming no other facts, first, individual A exercises substantial control over the company because individual A is a senior officer of the company, the president. Second, individual A is also a beneficial owner because individual A owns 25% or more of the reporting company's ownership interests. And because no one else owns or controls ownership interest in the LLC or exercises substantial control over it, assuming there are no other relevant facts, individual A is the only beneficial owner of this reporting company, and individual A's information must be reported to FinCEN. Example number two, the reporting company is a corporation. The company's total outstanding ownership interest are shares of stock. Three people, individual A, B, and C, own 50%, 40%, and 10% of the stock respectively. And one other person, individual D, acts as the president for the company, but does not own any stock. Assuming there are no other relevant facts, individual A, B, and D are all beneficial owners of the company, and their information must be reported. Individual C is not a beneficial owner. It'd be helpful I switch back here to this. Individual A owns 50% of the company's stock and therefore is a beneficial owner because 50% is greater than the threshold of 25% or more of the company's ownership interest. Individual B owns 40% of the company's stock and therefore is a beneficial owner. 40% is also greater than the threshold of 25%. Individual C, not a senior officer, does not directly or indirectly exercise any substantial control of the company. Individual C also only owns 10%, which is less than the 25% or greater interest needed to qualify. Individual C is therefore not a beneficial owner. Individual D, president of the company, senior officer, he has substantial control of the company, is therefore a beneficial owner, regardless of whether or not individual D owns or controls 25% or more of the company's interest. Example number 4. In this example, as we can see, individuals A, B, C, and F are beneficial owners. Individual A is the reporting company's chief financial officer and is therefore a senior officer, which under the reporting role means that individual A exercises substantial control over the company. Individual A also indirectly owns 27.5% of the reporting company's stock, the direct ownership of company Y, company Z, which each owns 50% of the reporting company's stock. Individual A owns 30% of the company Y stock and 25% of company Z stock. Therefore, individual A owns 15% of the reporting company stock through company Y and 12.5% of the reporting company stock through company Z. Adding those two percentages together equals 27.5% of the reporting company stock. Individual A, therefore, is a beneficial owner. Individual B owns 35% of the reporting of stock through company Y, which owns 50% of the reporting company stock. Individual B is a beneficial owner or controlling 25% or more of the reporting company's ownership interest. Individual C is the reporting company's chief executive officer. Therefore, he's required to report. And individual C owns 12.5% of the reporting company stock as well. Of company Z stock, and it's similar to individual C, individual D and E own 25% of company Z stock, and each individual therefore indirectly owns 25.5% of the reporting company stock. Individual F is on the company's board of directors and makes important decisions on the reporting company's behalf, therefore exercising substantial control. Individual F does not own or control any stock, but he is a beneficial owner because he does exercise substantial control over the reporting company, but not through ownership. Here's example number 5. So probably some of you out there have these type of structures. So we can see holding company, 0 employees. We have a sales company, operating company, IP holding company, no employees. Employee company has 3 employees, but no presence in the US. And they do have these 3 subsidiaries. As you can see, CTA reporting company not exempt. All of the subsidiaries would also be reporting companies. So you'd have to file BOI information for each of the blue entities there. Example number 6, again, another holding company structure. There we see the holding company has 21 employees. It wholly owns each of the other subsidiaries there. We have an employee company that has 279 employees. All of these would be exempt from the reporting requirements because the holding company would be a large operating company, and then each of the subsidiaries would be directly or indirectly 100% wholly owned. Another scenario, so here we have a holding company, 0 employees. We have a couple of large operating companies because they meet the employee requirements and the couple other prongs. And then we have 2 subsidiaries, subsidiary 2 and subsidiary 3. So as you can see, the ones in the green would be exempt reporting companies. The other ones in blue, they would be reporting companies, and you have to collect and file the BOI information. So that kind of concludes the presentation. What I think now we have some time for some questions, which I will go through those. Some of those that have been submitted. So I think we talked about one question related to the reporting of LLCs with multiple layers of membership. I think you have to look at if it's an exempt operating company, meets the requirements, large operating company, and any subsidiaries that were wholly owned or wholly controlled would be exempt from the filing requirements. But again, you have to look through the structure and see if there's large operating company exemptions, all the subsidiaries are wholly owned or wholly controlled. Somebody asked if you fit with one of the exemptions, do you have to file anything stating you're exempt? Again, no, you do not have to file anything if you were an exempt company. Implications, considerations for public companies. Again, if you're a public company, meet those one of those 2 requirements, you are exempt from the filing requirement. And for public companies that have wholly owned subsidiaries, they would also be exempt from the filing requirements. Somebody asked about corporate trustees need to be reported. In other words, they have to report the trust company, not the CEO, trust officer, compliance officer, et cetera. Well, I think what you have to do is look at, is the trust company itself exempt? Does it meet the large operating company exemption or another exemption? If not, then you have to look at each beneficial ownership issue. Who has control, who has ownership, the 25% ownership rule. So you have to look at that, and each of those would have to look to comply. I think we discussed kind of the latest CTA case filings. Somebody asked about that. Somebody asked about the beneficial ownership and its difference from actual ownership. I think we kind of covered that, but I think you've got to look at control, other issues with respect to ownership, look at convertible securities, voting agreements. things like that where control can come into play, or ownership of 25% or greater interest. Somebody asked about if the large operating company and they form a new entity, if that entity this year, if they file in 2024, if they form a new entity, it's owned by a large operating company that's exempt, that subsidiary, wholly owned, would be exempt as well, and no filing would be necessary. Let's see what else we have in the box here. All right. Let's see here. Is a law firm corporate in Illinois with one employee, the attorney who holds all the offices exempt? I would say no. There was no exemptions for law firms, unlike accounting firms. And we have a question. Please discuss the requirements of a trustee and trust beneficiaries if reporting company is owned by a trust. I think you would have to look through the trust itself. You have to look at those who control the trust. You wouldn't report just on the trust because the trust wouldn't be exempt. So you'd have to look through the trust and see who controls the trust and file the BOI information on those individuals. So you have a question on Wisconsin marital property. If title is in husband's name and the interest is marital property, does wife have to file BOI? So I'm assuming we're saying the property is held by an entity, an LLC. I guess you would have to look at, I'm not familiar with the marital property in Wisconsin, but look at the control issue, right? Could the wife as well as the husband exercise control over the entity? Then you would have to probably file on both the husband and the wife. Unfortunately, there's a lot more guidance out there from FinCEN on some of these questions dealing with these ownerships. I'm sure we'll get some things as we progress through this year. We'll have some more information and guidance sent out by FinCEN. All right, another question. Are all senior officers beneficial owners, even if they are not involved in any day decision-making in the business? Well, again, you're going to have to look at senior officers. I mean, I think by definition, depending on their role and title, one would presume that they do have a role within the entity. I guess if you're saying they're listed as CFO, but don't do anything with the business, have no day-to-day operations or control, they probably would be exempt from the filing requirements. But again, we haven't seen any guidance on that. So maybe for now, the best practice would be to file that information. Somebody asked how are the filings done, is electronic or paper? The filings are done electronically. So you just go in there, enter the information, upload it to the FinCEN website. Next question, how does someone, let's see here. How does someone file for beneficial owner under a power of attorney? Well, I think if based on that power of attorney, you have decision-making authority over the entity, control, other things, then you would have to file that information on the holder of the power of attorney. Let's see, next question. Any thoughts on allocating reporting responsibility between holding companies, employee active companies? We're using FinCEN IDs, but worried about permission to use those IDs and meet 30-day deadline reporting information of new entity. Any thoughts? I'm not sure the entity, I mean, the 30-day deadline, you have 90 days to file after the formation of the new entity this year. And you would file, you get the FinCEN ID, and then you would file the BOI information within that 90-day requirement. Let's see, we have, next question, we have a Florida limited partnership. that owns 99% of an LLC how to report that? Well, the Florida Limited Partnership, you'd probably, if the Florida Limited Partnership is not an exempt entity, then you would probably have to look through the indirect owners of the FLP to report for the LLC if the LLC is not otherwise exempt. Next question, are passive owners who have more than 25% equity ownership but have no control rights deemed beneficial owners? Yes, they would be deemed beneficial owners. The 25% ownership requirement does not have anything to do with anything with the control of the day-to-day operations of the entity. Let's see here. Next, is the conclusion that entities dissolved during 2024 must still be 2025 explicit statement set forth in CT or other official adopting commentary around it, or is that inclusion more just taking the Act's general text? Well, I don't think I've seen anything specific on that. I mean, I've seen some commentary from others, like law alerts and other things, because it really is complying with something that was created on before January 1st, 2024. There is no guidance on that. So as a safe measure, I would say if you dissolve an entity in 2025, you still, or 2020, I'm sorry, this year, 2024, you would still need to file the BOI information requirements. Hopefully FinCEN gives us some guidance on that. But I would say right now, if you existed, that entity existed prior to January 1st, 2024, dissolved 2024, you still need to file the BOI information. Let's see here. Is a state registered investment advisor required to comply with reporting requirements? Again, they would be required if they're not exempt. And you have to look at, there is an exemption. You have to see if one of the 23 exemptions apply. If it does, then you would not be required to file. Let's see, does the CTA apply to medical practices that are entities registered with the state? I would say if it doesn't qualify for one of the 23 exemptions, it would be required to file BOI information. There's no exemptions for medical practices, medical entities. Let's see here. Is a corporate treasurer the equivalent of a CFO for reporting purposes? Again, there's no guidance on FinCEN from that. I would probably say you default to say yes. If that treasurer performs similar duties as a CFO, they would be a senior officer and they would be required to submit BOI information. All right, our limited partnerships, reporting companies, any applicable exemption. If you registered, if that limited partnership is registered with the state, Secretary of State, and it's not otherwise exempt, it would be a reporting entity and you would have to file the BOI information. Do we know the timeline for 11th Circuit decision? Same with the Michigan case. Well, the Michigan case was just filed. 11th Circuit decision, I know that the briefs were just filed, so I'm not sure when the 11th Circuit will render their decision. Let's see here. Would a trust be required to file? My mother passed away last October and left me this trustee. Trust is a benefit of my disabled sister to be sure that she has a place to live. Okay, if the trust, generally trust, if they're not formed pursuant to state law, filing with the Secretary of State, they're exempt entities. So a trust, in most instances, I would think a trust would not be required to file any BOI information because it wasn't formed. Now, certain statutory trusts that filed, say, in Delaware, are required to file BOI information. But if a trust isn't created, nothing filed with the Secretary of State or other state agency, they would not be a reporting entity. Somebody asked, is there ever a third company applicant? The answer is no. Generally, they're only looking for the two people. So that is the one who directs the filing, and then the other party who files the information with the applicable state agency. Let's see. Do land trusts need to report beneficial owners? Again, if the trust isn't created pursuant to a filing with a state agency, then it's exempt. If the trust was created pursuant to filing with the state, then you have to look for another exemption, one of the 23 exemptions, to avoid the filing requirements. How does the Alabama case impact reporting requirements? Okay, so the Alabama case, that only applies to the plaintiffs in that action. They would be exempt right now. That's what the FinCEN, the federal government's position is. So if you're a plaintiff, you're a member of the National SBA as of March 1st, when the decision came down, you are exempt. Otherwise, if you file a new entity, you should comply within the 90-day requirement. If you can take a wait and see approach if you're an existing entity prior to January 1st, 2024. You've got, obviously we're in April, you've got till the end of the year. You can take a wait and see approach depending on the court outcomes as to whether you make the BOI filing. But I would say if we're getting towards the end of the year and these cases are resolved, then you definitely should collect the information and make the filing before year end. All right, is the employee exemption from beneficial owner only applicable to 25% ownership beneficial owners, meaning, for example, a CEO will not be exempt because they are an employee? CEO, because we have those senior officers, CEO being one of them, you have to collect the BOI information. The CEO is not exempt, nor are the other senior officers who have operating control, day-to-day management of the company. They all have to file BOI information. Let's see here. Does the senior officer category apply if an individual is a sole legal counsel for an organization but not present board meetings, suite meetings, or otherwise exercise responsibility normally associated with general counsel? I would say yes. If you have the role of general counsel in an entity that's not otherwise exempt, you would have to file BOI information. Let's see here. There are examples, FinCEN Small Entity Compliance Guide. There are examples to assist in determining beneficial ownership. In one, it's stated that individual F is on the company's board of directors and makes important decisions, thereby exercise substantial control with the assumption that directors are all involved in meetings, board decisions that comes to that. Does that mean that we should assume that all members of a reporting company's board of directors are beneficial owners? I would say yes. Absent guidance from FinCEN, most board members, pretty much all board members of reporting companies, you should collect and file the BOI information. Same with LLCs. If you're a manager of an LLC and you're actively engaged in business, again, you should file the BOI information. Okay, when an investor with veto rights automatically qualifies as an important decision maker. Again, I think you have to look at the control. This is very fact specific. If that investor can veto and have control over certain material actions of the company, then I would probably default to say they have control over the company and they would have to report BOI information. All right, let's see. Does the large operating company exemption apply if an entity meets the revenue office thresholds, but all employees are technically employees of the entity's parent company? If so, would the exemption apply to the entity? No, the exemption would not apply. Again, the large operating company exemption, that entity has to have more than 20 employees. You can consolidate the revenues, you can't consolidate employees. Somebody asked, do all these have to be met or just one of them for the large operating company exemption? Yes, all of those have to be met. So you have to have more than 20 employees. You have to have the physical office in the US. You have to have the 5 million or more in revenues. And you can consolidate too. I mean, that's the one. If you have a consolidated return for multiple entities, you can consolidate the revenues for that company that has more than 20 employees. Somebody asked about some strategies to assist clients that want to maintain anonymity in corporate filings. Again, I don't see, I mean, FinCEN, the requirements are there. I don't know how you're going to hide the beneficial owners or the 25% more or the folks in control of the entity. So I think FinCEN, they say the information, who gets access to is pretty limited. It's encrypted. We hope that information isn't hacked, but they're saying right now that it's going to be encrypted, and there's going to be a few government agencies that have access to the BOI information that is filed. So what is the attorney's responsibility to ensure that the client is aware that they need to file a BOI? What is the attorney's responsibility? The attorney sign the filing of the document informing the reporting company and the client does not want to file a BOI beneficial. Okay. So I think as attorneys, and we do this, I mean, we want to tell our clients that the filing requirement. We can only do so. I mean, I form an entity. I'm listed as a company applicant. We can only do so much to require or tell our clients to file. I don't think there's any liability on the attorney or the law firm if the client chooses to ignore advice and not file the BOI information. The company, its officers, directors could be subject to fines and penalties for willful failure to file the BOI information. But again, as attorneys, we can only advise our clients of the requirements, give them information about the deadlines. Obviously, newly formed in these 90 days. Entities prior to January 1st, 2024, they need to file by January 1st, 2025. But we as attorneys, I don't think we're going to be found liable for our client's failure, willful failure to file the required information. Somebody asked, can you explain the impact of beneficial owner requirements on directed trustees and direction advisors? The problem there is there's not much guidance dealing with that I've seen from FinCEN dealing with trustees and direction advisors. Again, I think it's going to be fact specific. Do you have control over that entity? If you're not a senior officer, but if you have control over that, you make decisions, management decisions, you're probably going to file the BOI information. Best practices for a question to determine ownership. I think, and we have not seen this yet. I mean, we're probably going to do something, I guess, for our clients later in the year about questionnaires that companies should send out on BOI, collecting the information, the data, and then updates. Again, I think most companies, if you're not exempt, you want to set in place practices and procedures to collect this information. And I'm sure we're going to see some things come out, and we as a firm will probably prepare something to send to our clients to collect this information and reminders and things like that. Does the senior officer requirement for beneficial owners apply just with corporations or with LLCs and LLPs? It applies to any entity that filed a document with a state to be created. So again, yeah, they would apply. If the LLC, LP, corporation file a document with a state agency, senior officer requirement, beneficial owner information needs to be collected and filed with FinCEN. Somebody asks who's liable for the violation of CTA failure to report. Again, the company would be liable. And I haven't seen much on this, but I would presume that the officers of the company who knew about the filing requirement and ignored it could also be subject to fines and penalties. Again, I look for guidance on that from FinCEN, but haven't seen anything on enforcement yet. And I assume we'll probably hear more of that towards the end of the year as these filings are being made, as we come up to the deadline of January 1st, 2025 for entities that existed prior to January 1st, 2024. All right, if you sell your business in 2024, you need to file a BOI prior to selling. There's just a requirement for new owners due before 12/31/24. Well, I guess if you sell the entity, the equity in the business, then the new owner would have that responsibility to file. If you sell the assets of the business to a third party and that entity existed prior to January 1st, 2024, then the owners who sold the assets would be required to file BOI information. If you sell the equity again, that new owner should be pointed out that they have a filing requirement, and they should look to file that before January 1st, 2025. Question, are you handling filings for clients or having clients handle their own filings? Again, we will handle the filing requirements. A lot of our clients will do that on their own. We suggest from a cost standpoint, we have a third-party provider that we recommend our clients use to file the BOI information. It's much more cost-effective, but we are more than happy to assist our clients with filing or assisting with getting them help in filing the BOI information requirements. Let's see here. Can corporate trustees be reported as the owner control person, or do you still have to look through to the CEO compliance officer? When we say corporate trustees, if it's an entity that is otherwise exempt, I think you would look through the entity to determine who the beneficial ownership information requirements are. I think as the question relates to you asking if the entity could file the information, but if that entity is not an exempt entity, then you have to look through to the individuals for the BOI information. We have a question, what third-party filer are you suggesting we use? We are using Capital Services for our clients, recommending them for the filing requirements. Do you know of any service companies that are emerging as strong resources in terms of helping entities file and update these reports? We've talked to a number of them. CT Corp is doing it, Capital Services. There's a number of others out there that are assisting companies with their BOI filing requirements. Let's see, are secretary and treasurer of an LP and or LLC considered senior officers for beneficial ownership? Again, I think you have to look at what those individuals are doing in their roles with the company. Again, we have senior officers listed, but arguably a secretary, corporate secretary, maybe they do not have to file for them, but a treasurer, if they perform the role of a CFO, then arguably you would have to collect BOI information for them. I think for the time being, I think the default is to be over-inclusive than under-inclusive until we get some more guidance from FinCEN on these particular issues and questions. We got a question here. What if you have a sole proprietorship that files a trade name with the Arizona Secretary of State? Does the CT apply? In that case, no. Again, sole proprietorships, they're generally not formed by filing a document with the state agency. And just because you file a trade name with the Arizona Secretary of State, you would not be subject to the CTA reporting requirements. Let's see, we got a question. LLCs that are open to hold property must file for all those owners that are part of the LLC, e.g. vacation home. Well, if you have an LLC that owns a vacation home, you have to file for the LLC, the managers, and then the owners owning 25% or greater interest in the entity. Somebody asked, is the BOI information filed with FinCEN public available? The answer is no. That information is not publicly available. Let's see here. Somebody asked, are there consequences to filing on someone when it isn't clear that the individual should be included? I don't think there's any consequences. I mean, the information is there. You can always go in and update the BOI filing if something changes and remove that person as a individual that's subject to the filing requirements. So I think we're at the top of the hour now. I want to thank everyone for attending. For these other questions, I will try to get back to folks for the ones that I did not or was not able here to address those questions. Again, thank you for attending, and we look forward to participating in one of the firm's other webinars in the future. Thanks.